state can never be bankrupt enough to not raise more money. It can only raise money at exceptionally high rates, which may not be feasible, but state will always raise money as opposed to a corporate which at a once declared bankrupt can't raise money.
So does it mean that those states which are poor, they have different treatment under international law because of their level of economic development? That's the normative argument you're making?
A company can be liquidated, and bankruptcy has an institutional endpoint, but a state cannot be liquidated, and it continues to govern, tax, and provide public services.
Do you see your proposal as requiring basically a deeper transformation in arbitral reasoning culture, meaning a move toward basically greater engagement with public law considerations? Do you see the excuse-based approach primarily as enhancing the practical enforceability and overall credibility of the system, particularly in global south context, or do you see it generally as I would say a more universal doctrinal refinement?
The Global South Network provides an important space to share experiences and learn good practices from one another.
Dialogue takes on a particular importance thanks to Global South Network, which allow us to believe in a better world of the rule of law.
It's a wonderful initiative.
The Global South Network opened new horizons for judicial cooperations.
Global South Network provide a platform for meaningful dialogue and cooperation, fostering efforts to build a more equitable and resilient legal landscape.
GSN Network continues to expand areas of activity, further strengthening its impact and reach.
The universal concept of justice compels us to join our efforts, and this is the forum for promoting the same goal.
Well deserved for the hectic activity you have made. I am astonished, I am amazed, I was impressed.
May I at the outset commend you, Dr. Ayad, for the immense work that you're doing in the GSN, and the Global South Network is a much admired initiative.
It's commendable. South Network focuses on all disciplines and regions, creating a bridge between academia, civil society, legal community, etc.
Good afternoon, everyone. It's my great pleasure to welcome you to the 7th seminar in Phase 5 of the International Interdisciplinary PhD in Progress weekly seminar series, which is organized by the Global South Network. Before we begin, I would like to extend my sincere thanks to Dr. Nauman Rayat, lecturer in law at Leicester Law School and founder and chief convener of the Global South Network, for organizing and leading this inspiring weekly series, from which I'm sure all of you will benefit today and from its future iterations. My name is Yarik Kryvoi. I am the Senior Fellow in International Economic Law and Director of the Investment Treaty Forum at the British Institute of International and Comparative Law. In addition, I am of counsel at Kieran Harrison and co-director of Arbitration Lab, where I organize, for example, the London Summer Arbitration School, the Basel Winter Arbitration School, where we have plenty of representatives from the Global South. And actually, at the end of April, we are organizing a seminar, ISDS and the Global South in India, and you will get information about this event in due course through the Global South Network. It's my pleasure to chair today's Global South Network PhD in Progress session, and I really look forward to the presentations and to the main presentation and to subsequent comments. Let me briefly introduce now the commentators, the discussant, and then the presenter herself. Dr. Charles Mark is the discussant for today's session. Dr. Mark is a lecturer in law at the University of Bristol Law School. He holds fellowships and academic affiliations at the Stanford Vienna Transatlantic Technology Law Forum, the Asian Institute of International Financial Law at the University of Hong Kong, and the Center of Chinese and Comparative Law at the City University of Hong Kong, and the Sovereign Debt Forum. He holds a PhD in law from the University of Glasgow and contributes to the legal profession as a member of the Trust and Succession Law Subcommittee of the Competition Law Subcommittee of the Law Society of Scotland. Prior to his current role, he taught at the University of Glasgow, Robert Gordon University, and the University of West of Scotland, and also served as a research associate at the University of Oxford. Valeria Manfredonia is the peer commentator for today's session. She's a doctoral researcher at the Faculty of Law, University of Cambridge, and her ongoing doctoral research examines the economic and institutional foundations of cross-border asset tracing and recovery in insolvency. Her research identifies the transaction cost frictions that hinder efficient recovery, such as information barriers, jurisdictional misalignments, and coordination failures. She evaluates how legal tools, procedural design, can improve value preservation and enforcement. Her project aims to develop a functional model of efficient recovery to guide reform and international cooperation. Finally, it's my great pleasure to introduce our guest speaker for today's seminar, Deepti Panda, who is a doctoral researcher at the University, at Queen's University, Canada, at the Faculty of Law of this university. Deepti is a litigator with over 18 years of experience in commercial litigation, domestic and international arbitration, cross-border disputes, and public interest litigation. Appointed as mediator and sole arbitrator in multiple proceedings by the Bombay High Court over 10 years, she has earned institutional trust for her independence and sound legal judgment. Currently, she is a doctoral candidate at Queen's University, where she is researching the intersection of public and private international law and the plight of insolvent sovereigns before international arbitration tribunals. She holds an LLM in International Dispute Resolution from Queen Mary University of London and law degrees from Mumbai University. Today, Deepti will present her PhD project titled Clash of Titans, Insolvent Sovereigns Against International Investment Treaty Arbitrations. She will speak for about 30 minutes, followed by 5-10 minutes comments from the audience. And I also hope that there will be at least 10 minutes for us to take questions from the online audience. Deepti, we are delighted to have you with us today. The screen and the microphone is yours.
Thank you so much for inviting me here. I am both excited and nervous to present my project. So the idea of the thesis, a little background on how we got here, is that it begins with a series of international arbitration awards which have been issued in the last 25 years. These awards have been of a value more than $1 billion at that relevant time. These countries were not in a capacity, and some of them even today are not in the capacity to comply with these awards because they simply don't have the money. A majority of these $1 billion awards are passed against Global South countries. The On the screen, you see some awards which are passed against Venezuela, Pakistan, again Venezuela, 8.5 billion, which was at that time the highest quantum award against any state to be issued, and then Egypt. A thing to remember is that each of these awards, the countries had proven that they simply don't have this kind of money. They cannot pay these awards. So that led me to think that everything is not right with the international economic law and the way the ISDS system is working. And I took a deep dive to see what exactly is happening in that space. Awards are issued against countries that obviously can't pay. Martin Paprinskis denotes these awards as crippling compensation awards, meaning that they cripple the economy. The effect is such that they are such high value awards that they will have a social, political, and economic effect on the country when the country seeks to pay against these awards. In my thesis, I take that definition and expand it a bit, because I don't only talk about high value awards alone, but I also talk about awards, multiple awards, which when passed against one single nation has the effect of crippling compensation. Most of us would remember the Argentinian crisis of 2000 and 2002. At least people who are as old as me or older would remember it as lived-in experience of the Argentinian crisis. It was hotly debated. The crisis caused a catastrophic economic, political, and social disaster in the country. The Argentine peso lost 40% of its value in just one day. The unemployment rate rose to 25%. There was rioting, violence on the street. People lost jobs. People were so much below the poverty line that they do not have access to basic food and healthcare facilities. Over 10 days during December 2001 to January 2002, 5 presidents changed their presidentship within the country. And on the last day of 2001, the country defaulted with a USD debt of $81.3 billion. As you can tell from the high value, even today, this sort of a money for a global south country, which is already suffering from economic crisis, this kind of a debt is almost not capable of being processed. What happened to the sovereign debt is not part of my thesis, but what happens thereafter is what my thesis is concerned with. So Argentina, to get over the economic crisis, undertook certain emergency measures. These measures included pegging the peso to the dollar. It froze bank accounts. It nationalized some companies, and it had great wide sweeping effects. It affected both domestic businesses, population, and it affected naturally the foreign investors. While the domestic population did not have any access to resorting against the measures that had been taken by Argentina, 43 ICSID arbitrations get filed by foreign investors, and at least 3 UNCITRAL arbitrations get filed against Argentina for treaty violation. The number is the minimum known number because international arbitrations can sometimes get buried under confidentiality clause. So these are the known numbers of how many cases got filed within a span of 2 years against Argentina, all arising from the economic measures that were implemented in the country. So in my thesis, describe sovereign insolvency as a phenomena where severe economic crisis is accompanied by exceptional circumstances, such as political instability, social unrest, which may not disrupt law and order, but does significantly impair the living conditions of the general population, including access to healthcare, public security, employment, maybe coupled with high inflation rate, usually is coupled with high inflation rate. And that's what I refer to as sovereign insolvency. I'm cognizant of the fact that sovereign insolvency as a legal concept is not defined in international law. And it's sort of a term of usage or coinage that I would be using in my thesis to describe these exceptional circumstances. So it's different from just an economic crisis, it's more, and it includes social and political ramifications. So in this background, this led me to a question: should there be a minimum standard below which no sovereign may be impoverished, no matter its contractual obligation and commercial indebtedness? As attractive as this question was, this, to my mind, led me down a philosophical debate and a philosophical quest. So, for my research, I use a more legal question, which is how sovereign insolvency may be invoked as a defense before investor state arbitration tribunals, and how tribunals can respond to such a defense while balancing investor and sovereign interests. The suggestion is not to discard investor interests, but it is to balance the interest between the investor. It's prioritize the population and balance the commercial interests, etc. Uh, for those who are familiar with investment arbitration and international arbitration, the next two slides are going to be boring. For the uninitiated, a quick sort of a explanation on what's going on here. Treaty-based international arbitrations are based on violation of treaty between the host state and the home state of the investor. The underlying agreement must have an investor state dispute resolution that refers the dispute to an arbitration. The claim is for breach of treaty, though typically a commercial breach of an agreement would not fit into treaty-based arbitration. But usually, investors do manage to satisfy the condition of a treaty-based violation, and a large number of these investor arbitrations fit into a treaty-based international investment arbitration. This is a consent-based adjudication system where parties choose the jurisdiction, they choose their arbitrators, they choose the procedure, they choose what law applies. So, and the next two things that are relevant here would be the New York Convention. The entire international arbitration framework largely gets governed by the two conventions which are on the screen, the New York Convention and the ICSID Convention. These conventions have, apart from various rules and binding obligations that countries have gotten into, 172 states for New York Convention and 165 for the ICSID Convention. That's almost a large 90% of the states are signatories to these conventions. What it really does, and what is relevant for my thesis, is that it makes the international awards which get ultimately passed by arbitration tribunals portable as well as enforceable across any of the states who are signatories to these two conventions. This is a very broad view of how arbitration is working in this space. The problem with, or the advantage of these convention is that an successive claimant of an arbitration award can just go to any state, enforce the award. There are very limited grounds of enforcing payment under these two conventions. So the awards that we saw in the second slide are going to be typically enforced against under one of these two conventions. Coming back to my thesis, it stands at the intersection of international investment arbitration, sovereign insolvency, and public international law. It concerns insolvent sovereigns before an arbitration tribunal, and which routinely defend investor claims on the basis that severe economic crisis created a state of necessity that precluded the wrongfulness of the government measures. It's a mouthful, and I'm going to explain that. And therefore, there is no liability to pay compensation. In simple words, what the states have been arguing is there is an economic crisis. It takes things beyond our control. The crisis can be justified under under the state of necessity. And because it can be justified, there is no wrongful conduct. Consequently, no compensation is payable. This very wordy and a mouthful of use, precluding wrongfulness, arises because of Chapter 5 of the ILC's 2001 Articles on Responsibility of States for Internationally Wrongful Acts. Again, this is a reflection of customary international law. It's not binding on parties, but most investor tribunals, when provisions under it is invoked, have engaged with provisions of the ARS. What Chapter 5 provides is circumstances that preclude wrongfulness and gives various circumstances. One of them, which is most often used by insolvent sovereigns, is Article 25, which is the state of necessity. What it does, provides an exception to the usual obligation of a state that the state must comply with all its treaty obligation, failure of which leads to compensation. Article 25 provides conditions under which a state could be exempted or justified in breaching treaty or committing an act which would have otherwise been wrongful. In the arbitrations that were filed against Argentina, in all the 46 cases, Argentina took up, amongst other defenses, took up a defense of Article 25 of necessity. It also took up what is known as a treaty exception, but for the purpose of today's conference, I'm not getting into treaty exception. I'm happy to discuss it if someone wants to discuss particular treaty exceptions, though that does form part of my thesis. In practice, the tribunals rarely accept this defense. The answer is obvious. A state cannot simply claim that it committed a wrongful conduct, but it is justified to do so, so it's not responsible. To put it in context, only 4 of the arbitrations of the 46 arbitrations that were filed against Argentina succeeded in only 4, and only on 2 of those cases did Argentina succeed in what I call a sovereign insolvency defense, but Argentina calls it a state of necessity. What it does is, as a result, because a defense of this nature is not accepted, there is a crippling compensation award passed against a nation which already is in crisis. So using a doctrinal methodology, my thesis examines how sovereign insolvency may be articulated as a defense and how tribunals could respond to it. The issue is not really that it can be a defense or not. It already is invoked as a defense. The question is that since that defense has not been working, how to make it work. We are lawyers, we must win. So I'm trying to find a solution on how to make this defense work. And we must, for that purpose, determine why it has been failing thus far. One of the reasons that states fail in their defense based on sovereign insolvency is first, of course, the more evidentiary and factual issue where they cannot satisfy the content of Article 25. But because it's a factual issue, it's not part of my thesis, it's outside the scope. What really my thesis is concerned with instead, and which forms the core focus of my thesis, is a theoretical examination on how these states frame their defenses and how can sovereign insolvency be classified. To my mind, sovereign insolvency can be classified either as a justification or as an excuse. The image that you see on the screen is uh, is really the difference that justification and excuse have. A justification based defense is where the wrongful conduct is justified and therefore there is no compensation. So, for example, if a man, if an army personnel during the course of a war kills people, the killing is not considered to be homicide or murder. He is justified in his action. There is therefore consequently no wrongful conduct and no compensation. On the other hand, the same person as a civilian, if kills people in self-defense, if the image that you see is he has a revolver, there are people trying to rob him. If in this scenario he kills in self-defense, the act doesn't become justified. The act becomes excused, meaning that the act of killing still remains wrongful, but he may be excused from punishment because circumstances existed that would excuse his wrongdoing. Some argue that it's potato, the consequence is the same. It really, theoretically, if you deep dive into the two concepts, it's not the same, especially in a context where I'm coming from, where we are talking about compensatory damages being the punishment, so to say. In case of a justification, the state argues that there is no conduct which is wrongful because the state of necessity or its sovereign insolvency created a circumstance that completely exonerates it from any kind of liability. As an excuse, on the other hand, the state accepts its wrongdoing, says, yes, I did wrong, and instead of seeking a complete exemption, what it does is seeks to excuse that conduct in the way of paying, for instance, delayed compensation or partial compensation or suspended compensation, sometimes conditional compensation. And that's something that has still now not been explored by any of the states who have taken up this defense. So the thesis identifies the research gap and argues that the outcomes may differ materially if sovereign insolvency is characterized as an excuse rather than a justification. One thing to remember is that the ARS doesn't classify the defenses either as justification or as excuses. There is, of course, research done to which way it could weigh, but there is no decisive finding on whether these defenses under Chapter 5 are justifications or excuse. So my central claim is that sovereign insolvency, when proved, can serve not as a preclusion of wrongfulness, but should serve as a preclusion of responsibility, where, when established, tribunals can hold the state liable for wrongfulness of its conduct, but recognize that the state may be excused temporarily, conditionally, fully, or partially from liability, even where a treaty breach has been found. This distinction reflects what Frederica Perdue refers to as the classification problem. Domestic legal systems, and especially criminal law, have a clear distinction on these issues. However, international law, this distinction gets muddier, but when we come to international economic law, this distinction doesn't exist. So far, states have been arguing necessity as a justification problem. Accordingly, tribunals have been rejecting that. But in the four cases that, in fact, Argentina succeeded, the tribunal has actually treated this defense as an excuse. So there is some source to say that perhaps, or presumably, framed as an excuse, there could be a little more acceptance from a tribunal level of such a defense. This distinction is rarely articulated by any of the parties, and even when it actually emerges, practice shows that it is not so intentional. It just has happened inadvertently or without much reasoning being given to it. So this is really what I am heading towards, that it is a It is departing from the prevailing justification-based approach of states. The thesis should argue that sovereign insolvency be examined as an excuse. My contention is admitting the wrongfulness of the act and then acknowledging that there is a duty to compensate, but the loss caused, but seek relief in the extent to which such a compensation is payable may give more relief to the states than what is being currently offered. This will also prevent states from taking this sort of a defense wrongfully, and therefore will address a lot of moral hazard issues that often arise when states are sought to be exempted from their claims. So awards that discuss the duty of compensation simply say that there is a duty to compensate. They do not explain the theoretical background on what is the duty is to compensate. And more importantly, what the tribunals have been failing to do is to identify whether such a duty would exist nevertheless, whether a state succeeded in justifying its conduct or making an excuse-based defense. So the plea for excuse is really says that there has to be an acknowledgement of wrongfulness of the conduct, and the effect is directly seen on the duty to compensate. However, for this consideration to function, I'm aware that states must change their stance and tribunals must reevaluate their approach. So the thesis contributes to the existing literature in two broad manner. First, it develops the theoretical framework for classifying sovereign insolvency defense within the IAF. And second, it demonstrates that this classification clarifies the consequences of such defense for liability and compensation. And on a sideline, it would perhaps also add more coherence to the series of awards that are being passed when dealing with this issue. Accordingly, the way in which a defense is framed and whether it is classified as a justification or an excuse will therefore affect the consequences of its successful invocation. Nevertheless, because it is overlooked until now and these two concepts are often conflated before arbitration tribunal, my thesis seeks to reconceptualize sovereign insolvency as an excuse-based defense and classify the same. And then it calls upon the ISA tribunals to reconsider the response to such claims. The argument is that the ISA tribunals must move beyond the predominantly private law orientation that they currently have and take into acknowledgement and engage with social, economic, and political realities that confront the state. The reason is that these realities of a state not only affect the legitimacy of arbitration, but it also affects the state's capacity and, in some manner, the willingness to actually comply with these awards. But since it's a work in progress and it leaves me with more questions than it answers for me, some of these questions will be answered in the thesis, in the sense that I will be in the thesis answering how to balance the investor claims and rule of law and how to get over the moral hazard argument that often is made against such a defense being taken. But there would be factors which would go beyond the thesis, which is the revisitation of international law. I do not aim to rephrase Article 25, nor do I intend to insert a new article in the draft articles, which has already taken, I think, roughly 30 years to get drafted and be in the current form. And I don't anticipate that there would be any value to me asking for an amendment to that article. So I leave with these questions and thank you for your patient hearing. I am looking forward to questions, discussing, and your feedback.
Thank you very much, Deepti, for this enlightening presentation. I certainly learned a lot. Let me now invite Charles to make his comments. If you could speak for about 5 minutes, Charles, that would be great.
Great. Thank you so much for Dr. Newman and Global South Network for inviting me. Thank you so much, Deepti, for your clear and thoughtful presentations on your thesis. So your project addressed a hard dilemma. When the state faces acute fiscal distress, it may have to choose between meeting commercial obligations and funding the basic public needs. So investor-state arbitration can then convert that crisis into enforceable awards with limited scope for review, which can deepen the pressure on already stretched public finances. So I took three main points from your argument. First, you identified there is a gap in how sovereign crisis-based defenses are classified in investor-state arbitrations and why that classification matters for the legal consequences. Second, you show that tribunals rarely accept economic crisis as a defense. States have often present crisis as a circumstances precluding wrongfulness, which is a justification-based approach. Tribunals have generally rejected that framing and have found liability. And third, your proposal more like a promising move that you treat the crisis not as the justification that makes the conduct lawful, but as the excuse for the conduct that remains wrongful. That keeps the idea of breach and accountability intact, while still allowing the law to recognize that performances may be temporarily impossible or unreasonable. So on your approach, the conduct remains compensable, but the obligations to make the reputation could be suspended, deferred, or reduced during the period of crisis. So I have two linked questions as you are going to develop your thesis. So my first question is kind of conceptual, and it's about the language that you used. So the phrase sovereign insolvency is widely used in your thesis. You even dedicate a slide for it, but it risks importing the corporate analogy that does not fit. A company can be liquidated, and bankruptcy has an institutional endpoint, but a state cannot be liquidated, and it continues to govern, tax, and provide public services. So what exactly do you mean by insolvency in your framework? Is it inability to pay the debt as they fall due, debt unsensibility over time, or something else? And relatedly, that you have mentioned about with the terms such as like sovereign debt crisis, sovereign debt distress, sovereign illiquidity, or even sovereign resolvency, better capture what you are trying to describe. That is a process of stabilizations and resolution rather than terminal conditions. So I ask because your arguments depends on the ideas of and of temporaneous, and the terminologies can help you to can help or may hinder that point. So my second question is practical, and this is about administration. So your proposal is attractive in principle, but tribunal will need a disciplined way to apply it. If reparations can be suspended, deferred, or reduced, how should the tribunal determine the trigger, the durations, and the content and the extent? So what indicators would you treat as creditable and objective? And who should bear the burden of proof? For example, would you rely on debt sustainability analysis, reserved adequacy, market assets, official primary balance trajectories, emergency social spending metrics, or a combination of all the things I mentioned? How would you prevent the test becoming either too rigid or to respond to a real crisis, or too open-ended to deliver the consistent outcomes? Finally, what would count as the end of the crisis for the purpose of resuming ordinary reparations? And should there be a built-in review point rather than a single all or nothing determinations? So one final thought follows from your excuse-based framing. If the breach remains, but payment is adjusted, there is also a question of fairness between different creditors and claimant. How do you avoid investor claimants being treated either as uniquely protected or uniquely disadvantaged compared with the other external creditors during the restructuring process? Put differently, should your approach track partly ideas that appear in sovereign debt practice, or should investment claims remain conceptually separate? So thank you so much, Deepti. I find your justification versus the excuse framing is a strong way to keep the legal accountability while making room for the realities of sovereign distress. I look forward to response. Thank you so much.
Thank you very much, Charles. Deepti, I hope you made notes about these questions, and I suggest that we go back to all questions after we hear from peer commentator from Valeria. Valeria, could you speak for 3 to 5 minutes, please?
Yes, absolutely. First of all, thank you so much to the Global South Network for the invitation. And secondly, thank you so much, Deepti, for this thoughtful presentation. It was very thought-provoking and very interesting. First of all, I will want to say that I found your justification versus excuse distinction particularly compelling, especially because it basically shifts the analytical focus from precluding wrongfulness to recalibrating responsibility and compensation overall. On this point, I have basically two reflections. First of all, I was wondering about the systemic implications of this shift. Basically, if sovereign insolvency is framed as an excuse that preserves wrongfulness but modulates responsibility, do you see this as operating purely within damages assessment, or does it subtly reshape how we understand responsibility generally in international economic law? So in a more broad way, I would say. The second one is that basically building on your point about the private law orientation of tribunals, do you see your proposal as requiring basically a deeper transformation in arbitral reasoning culture, meaning a move toward basically greater engagement with public law considerations? Or do you think existing interpretative tools are already basically sufficient to support this evolution? Finally, I was also interested in your remarks about legitimacy and compliance. Basically, do you see the excuse-based approach primarily as enhancing the practical enforceability and overall credibility of the system, particularly in Global South context, or do you see it generally as I would say a more universal doctrinal refinement? Once again, thank you so much for this presentation. It was very interesting, and I look forward to your replies.
Thank you very much, Valeria. And I would suggest that Deepti responds to these questions and within 10 minutes or so, and then we'll have some more time, 10 more minutes for questions from the audience. Over to you.
Thank you so much for those really thought-provoking questions. They are excellent questions. Some I have answers to, some I will attempt to answer, and some I will just thank you for. So first is the conflation of sovereign insolvency with corporate insolvency concept. In fact, the chapter 2 of thesis is all about distinguishing between sovereign insolvency and corporate insolvency. And it sets the framework on how the two are different, but at a theoretical level, they should have common goals. So for instance, what I try to explain is that the conception of declaring a corporate insolvent as bankrupt is to not only save the corporate, is not only to declare it so, but it's to protect the corporate as well, protect all the stakeholders and make an equitable sort of a distribution between all the stakeholders that are invested with the company, be it the workmen, be it debtors, be it shareholders. The concept, and I agree, maybe and this is something that I've been struggling with, maybe the use of terminology of sovereign insolvency can get confusing and can mislead people into understanding what I am getting at, because really what's for me sovereign insolvency at this stage means that I do understand that a state can never be bankrupt enough to not raise more money. It can only raise money at exceptionally high rates, which may not be feasible, but state will always raise money as opposed to a corporate which at a once declared bankrupt can't raise money. Uh, there are consequences which are different. And thank you for those ideas on how I could perhaps reframe the terminology. But today, what I really intend is that sovereign insolvency refers to something more than just plain economic crisis. And it doesn't refer only to the fact that a sovereign cannot pay its debts, but it cannot pay its debts without diverting from its sovereign obligations. So it's the balance of prioritizing between sovereign obligations and paying its debt. And when the sovereign reaches that stage, that's the stage that I'm talking about. So thank you. I need to think more on how I want to term it. So far as reparation and your point on when it becomes creditable, in the Argentinian crisis, there have been two tribunals who actually did come up with some solution. They excluded compensation which would have been payable for the duration of the crisis period, which the tribunal itself determined. Investment tribunals often do get into questions, though they do say that they don't get into policy questions, but they do weigh the validity of policy questions. And one of the tribunals, for instance, gives the example that it's not really the declaration by the nation, but more on the issue on where the tribunal finds the emergency period existed. And my idea is to have a framework that will make these reparations acceptable and determinable by the tribunal itself. It can't obviously be offered by the state because the state would be happy to say the crisis is still going on, I'm not ready to pay. And that's not the intent. And one of the reasons why the tribunal should decide is that it certainly can't be a self-justifying sort of a period. Uh, End of crisis, again, is something that the tribunal must determine. It's not an all for nothing game. That's exactly an all for nothing game would have been a justification based approach. The idea of having an excuse based approach is not to have an all for nothing, but some of something for all parties concerned. But you're right. There is a concern which I don't know how to solve yet. What happens to the small time investors? What happens to the smaller players? Because this seems to only take into account the big players, big investors into the crisis mode. I really don't know how to solve that problem. I hope the next coming period of my thesis solves that issue. Valeria, thank you so much for your comments and insights. They are extremely helpful. I do see it as limited to compensation, at least for the period for the thesis purposes. The reason is that anything broader than that is not going to fit within my word limit, and that's not going to fit within the time period. Maybe that's another paper in the making, monograph in the making, but not currently. Uh, Public law public law considerations are yes, one of the things that I did not mention for the purpose of this conference, but is part of my thesis, is I do build the reason why the tribunals must change their approach is based on what is known as a global public policy interest. It's develops on Andreas Kulik's work on what constitutes global public policy. And I do see that public law consideration would play a very important part of my thesis. So far as your point on coherence is concerned, for the purpose of the thesis, I am concerned with coherence for the simple reason that tribunals, despite being two or three big tribunals ruling in favor of states on economic crisis, because there is a lack of theoretical concept, tribunals don't have a yardstick based on which they are deciding these issues. They are receiving the issues and applying the law the way they think fit. And because there is no precedence value of these tribunal decisions, sometimes these decisions, as we have seen in the Argentine case, as we've seen sometimes in the Greek and Iceland cases, they vary significantly and they add to the confusion of what is being exempted, what isn't. While I address that sort of occurrence, I am not going to, for the thesis, touch on the larger issue of how the arbitration framework must change. I'm trying to work out a framework within the existing mechanism. I'm not trying to change the world, I'm just trying to change a chapter.
Thank you very much, Deepti. And we have a few minutes for questions from the audience. I invite those who are in the audience to raise their virtual hand if they wish to ask a question, and then introduce themselves and ask their question. In the meantime, while we are waiting, let me ask whether Charles and Valerie have any quick reactions to what has been said.
I don't have anything to add, but I maybe just my personal preference. I still think maybe solvent resolvency may be a better terminology to use, but this is your preference because this is your thesis. Yeah, thanks.
I don't have anything to add. All the responses were very conclusive. Thank you so much.
Sorry, you think that sovereign insolvency is a good terminology to accept?
Personally, I think it would be more accurate to say solvent, resolvency, not insolvency because a company. But if you can deliver that in your chapter 2, it would be lovely. But since I haven't read it, so I look forward to reading it if I have a chance in the future. Thanks.
Thank you so much.
Yeah, I have a question if there is no one in the audience. I'm interested in this argument about fairness. So does it mean that those states which are poor, they have different treatment under international law because of their level of economic development? That's the normative argument you're making?
No, I'm not. The argument is not based on poverty. The argument is based on a temporal nature of a crisis that the state suffers. It could be Greece, it could be America. If America reaches that and satisfies the condition that it was indeed going through a crisis, that it can't pay for general healthcare. Like what Pakistan did was that I can't pay for COVID vaccines. I've just taken $6 billion from IMF. Don't ask me to pay $5.8 billion to one single investor, at least now. Give me some time, I'll pay. So it's not a poverty-based argument. What it's saying is, if you make a case, if you succeed, this is how it should flow.
Mm-hmm. Thank you. And is there any effect of regime change or revolutions on the whole theory and on your arguments? So let's say a new government comes in and says, "Oh, we have nothing to do with it," and they put this, our country into this misery.
So that's the most frequently taken argument by most states. The previous government did it. I'm the good one. I won't do it. And that, to my mind, has almost always not succeeded. The government change doesn't. So the focus is on establishing the crisis, not being and satisfying the requirement of a crisis, which would be an evidentiary sort of a quest. It's not really on who was the bad boy, who did it. But overall, if it can be satisfied that as such, the country or the state is not to be blamed for the crisis condition. For instance, if it has happened because of COVID, it has happened because the international markets crashed at just that time, then you would be able to sort of make this case, but not only on the ground of the previous government did it. So really what I'm trying to say, it has to be a collective show of many factors which will go into showing the crisis, not just that was a bad decision by a bad government or a corrupt government.
Thank you. Very useful. And I certainly learned a lot, although this is not really my area of expertise. Are there any questions from those in the room? If someone has a question, please raise your hand. If not, I was wondering whether Nauman has any comments or final.
No, I think I enjoyed the discussion and the exchange of views. It was very interesting, something new for me. I mean, so I think, Yarik, if you want to add or want to give some comparative insights from other jurisdictions, feel free to do so. I think that would be very useful for Deepti.
Yeah, I was wondering whether whether you draw any parallels between domestic insolvency and international law insolvency, and how is it different at the moment, and in your opinion, or whether it should be changed. Maybe international insolvency should be more like domestic insolvency in terms of its principles. I mean, sovereign insolvency.
Thank you for that comment. In fact, that's my chapter 2. What I was just saying to Charles here, that in my chapter 2, I draw not only the distinction, but also the parallels. The parallels are on a more theoretical, philosophical basis of what is the real purpose and objective of insolvency. And then distinctions are on how the consequences flow. There are various factors which only apply to a domestic insolvency for corporate or for an individual, though individual is not part of the concern in my chapter, because an individual's requirement would be very different. But yes, I do draw that distinction very extensively. And I don't, since sovereign insolvency as a legal concept doesn't exist in international law, I don't see why I need to, or I don't see, at least for the purpose of my thesis, to reframe it. I am taking the concept, borrowing the concept as it is, and tweaking it to fit my argument, but not trying to change the insolvency world. And I think Valeria would be more concerned if I was trying to change the cross-border insolvency world.
Thank you. Well, if there are no further questions.
Thank you so much. Actually, these questions were very insightful. They were helpful, and I'm taking a lot of notes to think and ponder over. I want to thank everyone who is present here for taking their time off and coming here, especially the discussant, especially Charles, Valeria, and Yarik for for giving me such valuable insights. And thank you, Norman, for inviting me and organizing this beautiful conference every week.
Thank you. Thank you very much.
It was our pleasure to have you with us, and thank you for sharing your project with us. I mean, we learned a lot.
Yeah, and also many thanks to Dr. Mark and our peer commentator Valeria for their thoughtful, engaging feedback, and all those who were in the room with us listening to the presentation and the comments. And on a more general note, the Global South Network welcomes PhD students from all disciplines and from every corner of the world to share their research and receive interdisciplinary feedback. If you are interested in presenting your work or taking part in a future session, please contact Dr. Nauman, the founder of the network. You can see his email in the chat box. Well, goodbye, everyone, and thank you once again for being with us.
Thank you, everyone. Bye.
Thank you, Yarik, for excellently chairing the session. It was very well organized. Thank you.
Thank you so much. Thank you.
Thank you so much.